As I mentioned before, my name is DeDe Church. I've been an attorney for over 3 decades. Almost all of my career has been in the labor and employment field, and I've spent a lot of that time doing investigations. In fact, I've either conducted or overseen hundreds and hundreds of investigations, from the sensational, where a CEO has impregnated his assistant on the boardroom table, which has happened more than once, to the seemingly everyday, which is, somebody just feels like they're not being appreciated and they feel like their contributions aren't being valued, perhaps for reasons that should be protected. Whatever the situation is, it matters. It matters to somebody, and in some cases, it matters a lot. So again, I'm glad to be here to share with you some best practices going forward. I've arranged our time together into 4 modules. The first one is about when to engage an investigator and who to choose. And again, that's a really, really important decision. Then we'll segue over into what to tell that investigator after you've selected them, to try to avoid creating bias or tainting the process before it even gets started. Our third module will be on maintaining privilege during an external investigation. As you probably know, a lot of times you want to waive the privilege. You're doing an investigation so that you could show a fact finder later that you took prompt remedial action after you got a complaint. And that's fine, but it's nice to try to set up everything to be privileged so that you can make the decision to waive it, right? We don't want to make that decision for you. And then finally, what do you do if you disagree with what the investigator has to say? We're going to talk about all of those things. There's a QR code on the screen right now. That QR code should take you to these slides. If it doesn't work, my email address is dede@dedechurch.com, or you can reach me through my company website, which is also dedechurch.com. Please reach out. I'm always happy to share materials. Okay. So for our time together today, we're going to imagine that you are counsel for a fabulous new company called Lucky Penny. You adore this company. They are a great client because they're a startup and they are filled with employees who are young, very green, so they need a lot of advice, and genius. They know what they're doing. They're really good at what they're doing. But again, they need a little guidance. One of the employees of Lucky Penny is really going to garner our focus while we're together today, and it's this guy. His name is Riley, and he is the Chief Technology Officer. Well, let me tell you some things we know about Riley, all right? He is really good at his job, and he's critical to the organization because they're about to launch a new product and it's his baby. Riley's done everything, and he is the one who's going to get this product to launch on time. However, Riley is one of the people who spends a lot of time on screens. And what we're learning about people who live online is that they very often have underdeveloped interpersonal skills. In fact, if this interests you at all, there's a really great article written by Carolyn Bruckman of the Harvard Kennedy School. It's called The Friendship Recession. You might have heard of the loneliness epidemic. You probably know that even though we're all so interconnected, we're actually more lonely than we've ever been. And the friendship recession is correlated to that. What the friendship recession tells us is that we've forgotten how to interact. We've forgotten how to just have a friend. And the way that that translates into the workplace is that you may be seeing more complaints from employees who believe that what we think of as just a typical performance review, they see that as a threat, right? And so sometimes they're skewed in the way that they engage with others. And in our imaginary world, that is part of what's going on with Riley. Now, you've actually gotten some complaints, all right? Or let's say the head of human resources has gotten some complaints about Riley. Let's take a look at what they are, all right? The first one is that Riley's created a hostile environment, and that's the phrase that was used, based on sex, because he routinely hits on the interns. Recently, he placed his hand on one of the intern's thigh and sent her multiple inappropriate texts late at night. All right, so he's touching her thigh, he's sexting her late at night. What else, Riley? Well, she asked him to stop. And what do you think happened? Again, because he doesn't have very good interpersonal skills and he didn't know how to just receive her request and respond ethically, instead, he got drunk at the company picnic and talked loudly about how unreliable and disappointing this batch of interns are. Okay, maybe this feels familiar to you. In my world, on our team, we actually see this type of situation fairly often. And certainly hostile environment is a term that's in vogue. Employees use it, as you know, without really understanding the essential elements of that kind of a complaint. All right, so counsel receives this complaint from this intern and says, thank you. And then, then we usually reach behind our desk, grab a bottle of wine, because we know where this is headed. Riley is really important. And now we've got these complaints made about him. What are we gonna do, right? What are we gonna do? Well, the first decision is often made for us, okay? Are you required to investigate? There are a number of federal and state laws that require an investigation. In addition, you may have an internal policy or a code of conduct at the organization that likewise requires an investigation. But here, we're going to think about Title VII, which requires employers to investigate any complaint of discrimination based on race, color, religion, sex, or national origin. Of course, sexual harassment is a form of discrimination based on sex. This case doesn't involve the ADA or OSHA or the FMLA, but it could involve the Texas Labor Code, which is the state law that is parallel to Title VII and also requires employers to investigate certain complaints. So in this case, at least one federal law and one state law do require you to go forward with an investigation. And we know from case law that that investigation needs to happen immediately. We cannot wait for the product launch, unfortunately. I mean, assuming the product launch is not in 48 hours or something, right? We have to go forward with this investigation. Now, you as counsel for this organization might be thinking, I really want this complaint to be unsubstantiated because I need Riley focused on this product launch, right? So you might be thinking, how could I influence this investigation to be certain that the outcome is what I want? But will you act on that thought? No, you will not, because you know that you have an ethical obligation, right? To go forward with an investigation, not only for compliance, but also for effectiveness. So let's break that down a little bit, all right? You have to investigate for compliance pursuant to the laws we just looked at, but you also want the investigation to accomplish some things to improve your culture. So yes, we want to mitigate legal risk, we want to ensure compliance, and we want to demonstrate due diligence, but we also want to signal to our employees a commitment to fairness. Because do you think people talk about these things? They do. Despite our best efforts to try and ensure confidentiality, word gets out, employees are watching. This is part of the way that we can guide organizations to create a sustainable culture, to create a culture where employees want to stay, where we fostered a positive and trustworthy culture that people can rely on. And they can know if there is a problem, it's going to be handled and handled in the right way. So we want the investigation to be thorough. We don't want it to just skim across the top and come out and say, everything's fine with Riley, he can go back to work, right? Even though sometimes that can be a bit of a bitter pill to swallow. In case you need more persuading that a full and thorough investigation is the way to go, let me remind you about the Texas Disciplinary Rules of Professional Conduct. Rule 3.04 and Rule 8.04 both broadly speak to preventing you from interfering with the fairness of a proceeding, which would include an investigation, right? It would include trying to influence a third-party investigator. We as attorneys cannot unlawfully obstruct another person's access to evidence. We cannot destroy or conceal a relevant document, and we certainly cannot falsify evidence or counsel a witness to testify falsely. In addition, under Rule 8.04, We are prohibited from engaging in dishonest or fraudulent conduct. We know that we can't engage in dishonesty, fraud, deceit, or misrepresentation, or any conduct that would reflect adversely on our honesty. And in case you still need another reminder, ethically, we're also obligated under the Texas Lawyers Creed, which mandates that we as attorneys conduct ourselves with honesty, candor, and fairness, and avoid any behavior that might be seen as obstructing justice. So the ethical foundation is laid. We know what we need to do. Now let's try to figure out how to do it the right way. I think here, I'm still kind of in the introductory section, but these are really important things. Figuring out the role division, this needs to happen up front. And I'm going to tell you what I think works best based on, again, many opportunities to engage with counsel when it comes to investigations. I think maybe the most critical thing is who establishes the scope, who decides what the investigator is actually going to look into, right? In our case with Riley, are they going to look into the fact that this intern wasn't reliable, or are they going to focus on Riley's behavior toward the intern, all right? So the counsel, you get to decide that. The investigator, we're going to go with the scope that you create, understanding that as we go through the investigation, that scope might change based on what we learn, information we're given, information we uncover. And as soon as our direction starts to creep beyond that initial scope, our obligation is to come back to you as referring counsel or as in-house counsel and say, hey, I think there's something else you might want to look into, or the information is taking me in a different direction than we initially discussed. Can we talk about that? Secondly, the counsel's job is to oversee and provide access to documents and witnesses. Our role as the investigator is to tell you who we think we want to meet with and the documents we think we want to review. Now, you as counsel have oversight. So if an investigator comes to you and says, hey, I want to interview Mary Smith. She worked here 10 years ago, but she may have some institutional knowledge. It's within your purview to say, tell me what you think you're going to get from Mary Smith. And can we get that information elsewhere? Do we really need to involve an employee who hasn't been here for a long time, or maybe an employee who's gone to work for a competitor, or there could be a myriad of reasons why you think it's not a great idea to reach out to that person. It's within your purview to say, I think we're going to try to get that information elsewhere, right? You have oversight over that. You also get to decide whether the party can be placed on leave or disciplined. As an investigator, I'm often asked this question. It's not my role to give legal advice to the organization, right? That's what counsel's job is. In addition, you decide the format of the report. I think the best practice is for the investigator to completely finish the investigation and then to give you and anybody you invite to the meeting a very detailed verbal report. So you know everything that would show up in a written report. And only after that verbal report should you decide the format. Do you want it to be a one-pager? Do you want it to be a full report with exhibits or something in between? But it's up to you to get to decide that format. Our job as an investigator is to give you, again, that detailed verbal report and then to write the report if requested. Once you get the report, then you can correct any factual misstatement, of course, but you really cannot influence the findings or conclusions once it's in writing. And that's why that verbal report is really important. I get asked a lot about drafts. I'm not a big fan of drafts going back and forth between an investigator and counsel because we don't want anything that counsel does to appear as if it's undermining our independence. So I'm not a big fan of that. However, if you receive a written report from an investigator and you know there's something wrong, a date is wrong or a statement is wrong, absolutely reach out. We're going to talk more about that in just a moment. I think that the investigator is going to make ultimate findings only. They're going to say the complaints are substantiated or the complaints are not substantiated. You as counsel get to make the recommendations for what to do next. Now, there is some gray area there. Sometimes an organization will want their investigator to make a recommendation. And I think that's tricky. I don't think it should be done in the written report, because if you decide not to do what your investigator recommended, it could potentially at least appear to undermine the entire investigation. So we want to be really thoughtful about who's making the recommendation for next steps and how it's going to be conveyed. Maybe it's only conveyed verbally. I got a call recently from an organization, and they did an investigation over a year ago. The investigator recommended that their director of human resources be separated from the company. They disagreed, so they didn't do that. And they didn't really do much with the investigator's report because they so disagreed with that recommendation. They're now calling our team to look into very similar complaint that's arisen now, in part because it wasn't handled well before. So it's twice the cost, twice the fuss, and somebody else has been damaged because that initial investigator made a very strong recommendation without knowing how it was going to be received, and they put that recommendation into the written investigative report. Okay, we're going to move now into module 1. This is when to engage in an external investigator and who to choose. So again, you do have some ethical considerations in who you choose. You want to find someone who's neutral and independent. You want to avoid real as well as perceived conflicts of interest, all right? So for example, your best friend is an investigator. Probably not a good choice, right? Or someone who used to work for your external law firm is now gone into investigations. Let's bring that person in. Well, maybe, but it could also be perceived that that person still functions as an advocate because they were recently an advocate for your organization. So you want to look at it from every perspective. And what I mean by that is, if somebody involved in the conflict has had interaction with the investigator in the past, probably that person should not be the investigator for this conflict. We want to, again, step into the shoes of every party, make sure everyone's going to feel fully heard, make sure everyone's going to be treated fairly. And that's difficult when you start off with somebody that one of the parties already has a relationship with, good or bad. You also want to make sure that the person you choose is going to enhance transparency and accountability. You want to choose someone who's going to mitigate the risks, again, of retaliation or favoritism. You want to, in your choice, you want to support the organizational culture of integrity. You want to show that you were thoughtful about who you selected, right? And that makes a difference because, of course, ultimately, our ethical obligation is to respect the rights and dignity of everyone involved in this situation. So let's distill that a little bit. There are multiple situations that might entice you to bring in an outside investigator, but I want to talk about the 4 that I see most often, all right? The first one is when the complaint is complex or highly sensitive. A lot of concerns that we get involve sexual harassment all the way up to and including sexual assault. So when it's highly sensitive, it's very important. That's a good time to think about bringing in an outside person because you want fresh eyes and fresh ears, and you want a professional. Secondly, when a high-level official or human resources are involved. It's so unfair to ask an investigator to look into a complaint against their boss, right? So if a complaint is against a board member or a human resource executive, or really any C-suite executive, it's probably a good idea to think about retaining an outside investigator. When your internal resources lack expertise or availability, the lucky penny, as we know, is a startup. They may not have anybody who has experience with investigations. On our team right now, we are assisting an organization who's retained us, and their new investigator is going to shadow us on investigations. I love that. What an opportunity to share knowledge. That's really cool. So that's an idea. Maybe that might help some of your clients. And then finally, if you think litigation is probable, it's not a bad idea to think about bringing in an outside party. It's nice to be able to say to a jury, excuse me, this company did everything right. They were so concerned about this complaint that they brought in outside expertise to come in and look under every stone and talk to every relevant person. So, and that's, you're going to see in a moment, one of the questions that I'm going to give you in a template to ask potential investigators is, have you ever testified? Would you be comfortable testifying? And I think that's actually an important characteristic in an investigator. What are some other credentials that we can think of as blue ribbon? I believe having a law degree is helpful. I want to be very upfront about this. An investigator does not have to have a law degree, period. That's not required. But in my experience, having a law degree can be helpful. A lawyer, especially if they have labor and employment expertise or experience, they know how to make sure that a comparator is similarly situated, for example, in a complaint of discrimination, or how to see if an excuse or a justification is a legitimate non-discriminatory reason for a performance action, or if it's pretextual. So I think this is the blue ribbon credential. Again, is it required? Absolutely not. But I think having a law degree is something to consider. And I know that there are excellent investigators out there who are not part of a team. So I want to be clear about that. But in my experience, having teammates to brainstorm with when things get complicated, and even more importantly, having another set of eyes on a written report, that is worth any extra cost. Yes, an individual investigator may be less expensive, but that possibly slight extra cost, in my mind, is worth it. I'll give you an example. I'm lucky enough to serve as an expert witness for organizations who, in cases where an investigation is being questioned, right, whether or not it was good. And I've testified for both sides, for individual employees as well as organizations. But I did have one case where an investigator wrote in his report that a witness was lying because of the way she flipped her hair when she spoke. Now, you know, demeanor in an interview can be one factor in deciding credibility. But something like a hair flip, that might be a cue. You might think, oh, she hasn't done that before. This makes me think I want to ask more questions based on her demeanor. But I'm not sure I know that I personally would never write that in a report. And this investigator did, and that was part of the reason that the company ended up being sued, because the woman who flipped the hair was the complainant, and she did not like that, as you can imagine. She certainly didn't like being called a liar. And it was a tricky case. Part of having a team is that you always have another pair of eyes to read the report. And I think if somebody else had read that report, they would have caught that. And they would have said, help me understand why you're putting this in writing in the report. Is it necessary? So that's what I mean. Having a team, having somebody else, and frankly, just to remove the typos, it's a kind of a joke on our team. We all work really hard, but we all make typos, myself included. And it's just nice to have somebody catch those. It's important that you have a consistent process. So if somebody asks, you can say, yeah, let me walk you through our process. This is how we handle every investigation, because this is the best practice that our team has come to rely upon. And it's certainly nice if you can choose an investigator who's recommended by somebody you find trustworthy and reliable. All right, let's do the flip side now. What are some red flags, some things that you might want to look out for or consider when you talk to an investigator? Some of these are going to be very, very obvious. For example, if you're talking to a potential investigator and they don't ask about the scope, they don't ask any questions about the scope, they just assume they know what you want, that's probably a red flag. Similarly, if they don't ask for any relevant documents, no, I don't need any paper. Typically, you want an investigator who starts off by saying, I'd love to see a copy of the complaint if it's in writing, certainly any relevant policy, if there's an org chart that might be helpful, if you've gotten emails from the complainant, anything that exists that's in writing. Do you have a code of conduct? Those are the kinds of things that you typically would ask for as an investigator. Is this person a poor communicator, or are they evasive when asked questions? Well, one of the key characteristics of a good investigator is that they're a good communicator, because they're going to be sitting there, hopefully on the same side of the table with the witnesses, because good investigators know if you're sitting across the table from me, I can't see your body language, right? But you're gonna want somebody who can easily communicate with your witnesses. And some of these cases involve C-suite executives. You want someone who's going to be confident when they go in to talk to a C-suite level exec, right? That somebody who instills confidence and also is able to put people at ease so that they are comfortable sharing information. And finally, you don't want someone who presents themselves as an advocate or someone who is argumentative. This is a curious trait. As you know, you want an investigator to be a neutral party. And yet I have met investigators who see their role as being an extension of counsel. In other words, counsel is an advocate, so I'm going to be an advocate. And when they get into witness interviews, they badger the witness or they come in very aggressively. That's not the way to handle an effective investigation. Okay, what I'd like to do now is give you these 10 discussion points. And again, I think you can access these materials, but if not, just email me and I'll send these to you. You may not want to ask all 10 questions, but this is a pretty good guide when you are interviewing an investigator. This is based on questions that I've been asked, and I've included the answers that I typically give. So I hope you'll find this helpful. So of the 10 questions, and we can go through this fairly quickly, please describe your overall approach. Generally, your approach is being thorough without causing unnecessary disruption. Are you searching for a policy violation, a legal violation, or only to substantiate allegations? And it's the latter. Your investigator should be working only to substantiate or not substantiate allegations. They're going to give you all the information that you need to determine whether or not your policy's been violated. That's something that you as counsel can handle. And frankly, no investigator should be coming back saying a law has been violated. That's way beyond the scope of an investigator. All right, number 3, how will you handle scope creep? And again, you want somebody who's going to say, I'm going to come back to counsel before pursuing any new allegation or talking to any witness not previously mentioned. Number 4, who's going to invite these witnesses to the interviews? In our experience, it's best if the company rep does that, whether it's you as counsel or somebody in HR or some manager that's not too involved in the situation. And it's best if they can send an email and copy the investigator, inviting or introducing the investigator to the witness, and then the investigator can immediately follow up and set up that interview. And as far as when to do it, you don't want much time to elapse. As soon as that witness hears there's an investigation, we want to set up that interview really quickly. Because when time lapses, you know what people do, right? They talk, of course, and we want to try and prevent any gossip so that it won't undermine the integrity of the process. All right, number 5, do you record interviews? This is a really important question because different investigators handle this very differently. Since I'm the one here talking, I'll tell you that on our team, we don't record interviews. I do think it changes the vibe in the process. We're just trying to be relational, and put this witness at ease and get information. However, we take copious notes, and at the end of every interview, we read our notes back for accuracy. We want to make sure that what we've written down is accurate. And also, it reminds the witness of everything they've said so that later, hopefully, they won't come back and try to say, I never said that. because we've got on our record that we read the notes back and that they were approved. If your company policy is different, maybe you do record all of your interviews, then just make sure that this investigator is going to follow your company policy. Every investigator should be flexible and malleable enough to follow your preferred process. All right, a few more. When it comes to notes, do you keep notes of conversations with counsel? This is a curious question, I realize, but sometimes counsel says a little more than they should and tries to influence the investigation. And if that's captured in your investigator's notes and you're unable to privilege that and it gets turned over, it can again undermine the fact that this was intended to be an external investigation. So you want to find out if they keep those notes. Do you read your notes back to ensure accuracy? And if it's a public entity, have you dealt with the Public Information Act? Do you understand, in other words, that any note that you take down might be requested under the Public Information Act? Number 7, do you make recommendations? We've already covered that. And the answer hopefully is not in the actual report. Number 8, who will circle back with the parties to tell them the outcome of the investigation? In our experience, it's usually best if HR or an internal manager handles that and the message comes from the organization as opposed to the investigator. Are you comfortable testifying? And finally, how do you discuss confidentiality with witnesses? This is not meant to be a trick question, but it is it's something that an investigator needs to understand. Specifically, a case called Stericycle came down in 2023. This was under the National Labor Relations Act. And this continues a battle between the National Labor Relations Board and the EEOC over how much confidentiality can be requested during an investigation. And the kind of median decision point, the National Labor Relations Board allows the investigator to request, but not require, confidentiality while the investigation is pending. So, well, actually, that's written almost incorrectly, and I'm the one who wrote that. We can require confidentiality, but only while the investigation is pending of non-supervisors. Supervisors who are not subject to the National Labor Relations Act can be directed to maintain confidentiality. But a non-supervisor, it is suggested that they be required to maintain confidentiality only while the investigation is pending. And that request has to be narrowly tailored for the reasons that you can see there on your screen. One of those, at least one of those, needs to be present. So it's good to have a conversation with your investigator to find out, how do they handle this? What do they do to try to ensure confidentiality? All right, module 2, what to tell the investigator to avoid creating bias or tainting the process. This is huge. It's so hard to bring in that external party, again, to look through the dirty laundry, if you will, and not influence them. You really have to work hard to give an ethical case overview, but that is the goal. Now, what does that actually look like? In general, you want to provide complete and accurate information, but you want to skip the subjective opinions, right? You want to avoid emphasizing unproven allegations. For example, in our case, that involves the complaints against Riley, we want to try not to say the intern who is complaining about Riley is probably the one who wasn't going to get a full-time job offer, right? You might think that, but we don't want to say that to the investigator because we don't want to try and sway them, overtly or quietly before they've even started the process. We want to present all relevant information to the investigator, even if it's unflattering. For example, you might have to say, you know what, we got a similar complaint about Riley last year, but we didn't fully investigate it. That's really important for the investigator to know, because when it comes to determining credibility in like a he said, she said case, or he said, or she said, one of the things we consider is a prior pattern of behavior. So it would be good for your investigator to know that there was a prior complaint, because that might very well play into the determination of whether or not this complaint can be substantiated. And of course, try not to suggest conclusions or expected outcomes by saying something like, I'm sure you'll find Riley credible and you'll confirm that this whole matter was a simple misunderstanding. That is obviously stepping over the line. You know what, I'll tell you what normally happens when I get the call from an organization or from counsel and they're retaining our team to do an investigation. A lot of times I'll hear this, well, I don't want to influence you, but, and then whatever comes after the but is almost every time an attempt to influence us. Luckily, most investigators have heard that many times and they know how to compartmentalize that. They're still going to do a thorough investigation. You want to think about now who's driving this investigation, right? So you want to clarify what the investigator's role is and try to reinforce to the investigator that they act independently. So you want to avoid giving them specific direction and you want to support their autonomy in their methodology. In other words, you still have oversight, but if they ask to see certain documents and when you ask why, they have a valid reason and it ties very directly into what they're ultimately trying to answer. In that case, you want to support them, right? You don't want to question or push back on that too much. And you also want to define boundaries for communication. And this is really important. Do you want to be involved every time the investigator speaks to the parties? Probably not, is my guess, not only because it's time intensive, but also because the investigator is really trying to form some form of a professional relationship with the parties and to earn their trust. And sometimes that works better one-on-one. But if it's your practice, it's in your procedure that a second person, an employee of the company will be present, then by all means, let's do that. And that works beautifully as well. You just need to talk about it in the beginning so you can understand it. So let's try to set the scope, all right? In our case with Riley, on our team, we like to set the scope starting with the word whether, as in whether or not. So number one of the scope would be whether Riley has created a hostile environment. And we're going to use the phrase hostile environment because that is the phrase that the complainant used. When you're setting the scope, you always want to use the exact phraseology that the complainant used. If they didn't call it discrimination based on gender, then that's not what you'll call it when you set the scope. So whether Riley has created a hostile environment based on sex by routinely hitting on interns, placing his hand on one intern's thigh, and sending the intern multiple inappropriate texts late at night. The second part of the scope is whether, after being told to stop, Riley talked loudly at a company picnic about how unreliable and disappointing the interns are. And a possible addition, depending on your code of conduct, whether Riley got drunk at a company picnic, in case that would be seen as a violation. Certainly for some of our clients, that's part of the culture and that's not something that would need to be investigated. Obviously it depends on the organization. All right, so we've set our scope. Now let's move on to module 3, maintaining privilege during an external investigation. So as we've already stated, it may not matter, right? Because you may feel like, well, I'm going to waive the privilege because I'm going to want the judge or jury to know that we did this investigation. I'm not going to try to keep it secret. But again, it would be nice for you to have the option. So I think it's important in the retention stage with an external investigator that you do everything you can to maintain that privilege. Now, very generally, you already know this, there's 2 types of privilege that could potentially come up in an investigation. The first one's the attorney-client privilege, which protects confidential communications with legal counsel, and that does extend to communications with outside investigators if they're under counsel's direction. The second type of privilege that we're not really going to cover here is attorney work product, and that protects documents created in anticipation of litigation. So we're going to imagine in our case with Riley that no one's filed a lawsuit yet or filed an EEOC charge, so we're not able to rely on the work product privilege. We want to focus in on the attorney-client privilege. Here's the question that I believe courts will ask. Now, at the outset, let me just say that we always say the question of whether privilege attaches is sort of like a baseball game. You don't know if it's a ball or a strike until the umpire calls it. We don't know whether an investigation will be privileged until a judge decides it, right? But we do everything we can to try and privilege things. And we know based on case law, the question that's critical is, was the investigation conducted for the primary purpose of providing legal advice instead of just general business advice, right? So for example, let's say you're trying to privilege the investigator's notes that they took during the interviews and notes of their thought process as they went through the investigation. Notes from a routine or typical human resource investigations, they're probably not protected, but they might be if counsel directed the investigation specifically to provide legal advice. So the way the courts look at this is the distinction between, are you doing this for a business purpose? This investigation for just a business purpose, you got to complain, it's just your practice, you have to go through these steps. Or are you doing it so that information can be given to counsel who will then advise the organization on how to move forward? We want to go for the latter because that's the only one that would potentially cloak the investigation in privilege. Now, here are some best practices, all right? You want to retain your investigator through your legal department or counsel. If at all possible, get a lawyer to sign the engagement letter. Secondly, clearly define the investigator's legal purpose and scope, and you can do that in the engagement letter. I'm about to give you an example and some sample language. Third, if it's document intensive, go ahead and set up a privilege log to track all of the privileged communications. Frankly, in most investigations, this is not the case. You won't need a privilege log, but it is smart to try and communicate with your investigator verbally as much as you can. Try not to use email or text for really substantive communications. And then finally, instruct your investigators on confidentiality and privilege obligations. And again, you can do that in the engagement letter. I want to call your attention now to this case. It was UT System versus the Franklin Center. This came down in 2023, and it's really the best case we've had on privilege and investigations, well, ever. In this case, the Texas Supreme Court really did expand the protection for investigations. This case involved UT had hired an external investigator. He was not a lawyer, and the Franklin Center filed a PIA request. They wanted that information, public information, and UT fought it. And it got all the way to the Texas Supreme Court to decide whether or not UT had to turn over the investigator's notes. So that's what this case was about. The Supreme Court said there were three factors: whether the lawyer hired him, whether the lawyer directed him, the investigator, and three, whether the non-attorney investigator was expected to keep the records confidential. The key finding here is that, well, first of all, you can have a non-lawyer investigator, which we've already covered. But in addition to that, communications between the non-lawyer investigator and the university were privileged because of the purpose of the communications. They had been made to facilitate legal services, right? And so it didn't matter whether or not the investigator was a lawyer. It mattered more the purpose of their communications. And this case does suggest a more expansive view of the privilege, but remember that it was tied to Texas Rule of Evidence 503. So if you practice outside of Texas or it's a federal case, this won't be helpful particularly. And it also really focused on governmental entities. So we're not sure how much this will impact non-governmental entities, but I did want to make you aware of this case. And the takeaway there, again, is that you should document that the actions of your investigators, especially if they're not attorneys, are at the direction and under the supervision of legal counsel for the purpose of providing legal advice. Now, I also just want to bring this case to your attention. It's old, it's from 2016, and it's from California. But if you do any sort of research into privilege and investigations, the Petaluma case always comes up. This involved the courts figuring out whether or not an investigation constitutes legal services. And in this case, they did find that an outside investigator was providing a legal service or advice because they weren't simply acting as a fact finder, but they were expected to use their legal expertise or their law degree to identify facts, synthesize evidence, and come to a conclusion about what actually happened. So this is just a good foundational case, even though I recognize that it's California. It just still comes up anytime you do research on this. It's a well-known case. I wanted to also just share this with you in case this is helpful. This is language in our actual engagement letters at DeDe Church and Associates. As you can see, we say that our company, through its consultant, will provide Company X a confidential and privileged neutral investigation into specific identified employee concerns that could be the subject of future litigation. And then this next paragraph is really important. It is our shared understanding that the investigation will be privileged and confidential, that this legal service is at the direction and under the supervision of legal counsel, that it is intended to aid counsel in formulating and providing legal advice for Company X, and that our services are necessary or at least highly useful for effective consultation between Company X and its counsel. And then finally, you need to speak to confidentiality. So our attorney consultant will rely on their legal expertise to provide this professional service and will maintain all information gathered and related communications as strictly privileged and confidential. So in case this helps, this is the language that we've settled on based on our review of all the case law. If you have something that should be added, please speak up now if you're watching the webinar live, or again, if you're watching it later, please let me know. We're now coming down to our final module, and this is module 4. What do you do when you don't like the result you get, when you don't agree with the result that you get? Can you dispute it? I mean, the short answer is, of course, absolutely. So what might have happened that could cause you to disagree with the investigator's finding? You may have realized through the course of the investigation that your investigator is biased for one reason or another. You may believe and actually be able to show that the investigator misinterpreted some piece of evidence, or there was a procedural error in the way that they went forward. They might also have misunderstood, if it's a highly technical case, again, an investigator should be able to hop into any industry. I know on our team, we've done everything from specific eye surgeries and lots of things happening out on oil and gas rigs, even my favorite pizza shop, and the way that pizzas are prepared. Your investigator can learn what they need, but if they misinterpret some technical component of the investigation, that might be a reason why you decide you're going to dispute the finding. And again, the one we've talked about so often is a flawed recommendation. All of these things are examples of why you might disagree with your investigator's findings. Now, let's imagine that, let's go back to our case against Riley, or our complaints against Riley that we're investigating. Here are maybe some of these things happened. Maybe there was bias. Maybe the company engaged an investigator who recently retired from their outside law firm, right? Or maybe the scope was the problem. The investigation began without a clear plan and allowed the scope to creep from the initial allegations to unrelated performance issues of the interns. Maybe there's confirmation bias. The investigator spent more time trying to undermine the intern's credibility by focusing on her performance than on examining the validity of the actual harassment complaint. Or maybe the investigator relied on secondhand accounts instead of looking at the actual texts that Riley sent. And finally, maybe the intern was never given a full opportunity to respond to what Riley said about her with regard to whether or not she had some performance problems. So as you can see, even this made up investigation that we're knee deep in right now, even it offers a variety of reasons why an investigation might not go well. So let's imagine that you don't like the finding. You don't think that it's valid, and you don't think that you ethically can endorse what the investigator has found. What do you do? first and foremost, do not ignore it. Don't just pretend like you never got the report and go about your business and never mention it, because it will come back. It will raise its head, and not in a good way. Certainly, you've got to, at a minimum, get back to the complainant and to the respondent to let them know the outcome. So that's you're not going to ignore it. All right, communicate with the investigator. You absolutely should contact the investigator and hey, can we talk this through? I'm really curious how you ended up substantiating this concern or not substantiating this concern. It does happen. We once had a case where a client trusted us with some complaints against a manager. They had been getting complaints against this manager for years, but the complaint that they gave us to look into, we couldn't find any information to substantiate it. There was no one who could say, yes, the manager did that. There were no documents. There was nothing. And the manager had a really good explanation for what happened. So we couldn't substantiate the complaint. The client was frustrated because they said, but we've gotten all these concerns. Yes, but this concern, the one that you gave us to look into, we couldn't substantiate that. And when we had that communication with the client, they fully understood, and steps were taken, and the right steps were taken. So you got to talk these things out, right? So that you understand why the investigator made the decision that they did. Then you want to go back through the report on your own. Really analyze it for the flaws that we've just discussed. Really look for that. And you may even want to create a task force or give this to a couple of people who can analyze that final report and then conduct an internal reevaluation of the report. Not necessarily redoing the entire investigation, although maybe in some cases that's what needs to happen. But then you want to address anything, especially factual inaccuracies that you can show were wrong. And then you want to be prepared to justify the decision. Frankly, I think it's a good idea to put that in writing, a justification at the time, so that if a concern arises years later, you have a contemporaneous document showing why the decision was not followed or was disagreed with by the company. Lastly, I really want to talk about this. The thing about an investigation is that it is almost always disruptive. We do the absolute best that we can, all of us investigators. We do everything we can to give you the information you need so that you can make the right decision. But getting that information is sometimes really, really disruptive. I have experienced organizations that the investigation is into very serious complaints about the leader of a department or a group. And the complaints are substantiated and the leader is separated. And nobody ever addresses it with the team. They just come to work the next day and the leader is gone. And they're told that an interim leader will be hired. Somebody else is coming. But in the meantime, they're just on their own, wondering what happened, wondering if was it something they said that got the leader terminated? So I don't know, maybe this is sort of a bit of a personal mission of mine, but there are things you can do. I know that we all want to protect confidentiality, and it's not a good idea to, once a leader is separated, to go back to that team and say, oh my gosh, well, we got rid of her. Let me tell you why, right? That's not a good idea, but you can structure and offer a facilitated restoration gathering. That's kind of the euphemism that we use on our team when we conduct these. It's really just an opportunity to gather the team together, first and foremost, to say thank you. We are grateful to everyone who participated in this investigation, who came forward and truthfully and thoroughly shared information that we needed to try to improve our workplace, right? So it's a thank you. Obviously you can see that Mary Smith no longer works here. We want to talk to you about plans, what's going to happen next. So in other words, you can, I don't know, bring them together. And especially if a senior level executive leads that facilitated restoration gathering with some notes that you draft, with some scripted comments, it can go a long way to just quelling those fears and to making people feel like that investigation was a good thing. It was handled well. It was handled ethically. I'm really glad that I work for a company that took that seriously, and I'm going to stick around, right? I'm going to stay. It's a great way to retain your talent and to begin, if you haven't already, to create a culture where people feel trusted and feel like they're going to be heard. That brings us to the end of my time with you. If you have any questions right now, please send them in. I think we've got about 2 minutes to try and answer them. Or if you have a takeaway, something that you particularly enjoyed hearing or plan to put into your practice, or something that you would really like for me to start doing, please let me know. Otherwise, I am just really, really grateful for this opportunity to talk with you. I take investigations very seriously. Obviously, they're a big part of my practice. And I know personally how an investigation can either improve a workplace culture or it can unintentionally do a lot of damage to a workplace culture. And so I'm really grateful for the chance to talk with you about ways to try and make sure that the investigations you undertake, particularly when you're bringing in an external party, be sure that those investigations, all the guardrails that are out there, that you put those guardrails in place, that you do everything you can, control everything you can to be sure that that investigation ultimately is successful. And by successful, I mean that they find the information that's factually accurate and thorough, and they give that information to you so that you can continue to guide and lead your clients in the right way. Many thanks for being here. Take good care. Bye.